Welcome back. If you remember from module 1, we broke down and highlighted the major gaps that this law firm, Halstead Co., in the scenario, the gaps that they have with regards to being compliant to the ISO 42001, because they have rolled out AI. In this case, it's ChatGPT, Copilot, as well as Leap AI, which is a specific AI tool for law firms. And they've rolled this out without the relevant documentation and frameworks in place. Hence why there are 9 gaps. So in this module, we're going to address gap 1. Okay, so for module 2, the scenario story is the Tuesday the questionnaire arrived. Now, throughout this module, I would like you to put yourself in Priya's shoes. So you're going to pretend that you're the COLP for Halstead Co. Okay. Now, Halstead & Co.'s largest panel client has just sent over a 5-question AI governance questionnaire with 30 days to respond. So there's a 30-day deadline. Now, question 1 is what matters right now in this module. And at the moment, Priya can't answer it. And this is the gap that this module will close. So, quick summary. You've got the firm, Halstead & Co. The client pressure is coming from Pemberton Capital, who brings in a nice £620,000 a year revenue for Halstead & Co. They have a deadline of 30 days from receiving the questionnaire. And the risk that Halstead & Co. actually face is losing or damaging that relationship they have with their biggest client. Now, the one question, or question 1 on that questionnaire, from Pemberton Capital is, do you have a documented AI policy? Now, what did Priya find when she searched the Halstead & Co.'s management system, document management system? Well, let's find out. So, Priya opened the firm's document management system and searched for AI policy. That's what you'll naturally start with, right? She got no results. She then broadened the search and she typed in artificial intelligence. And she also tried AI governance. And what she got was one single document that had 2 paragraphs. And it was a note from the IT director, that is Marcus Webb, dated back in March 2025, just making a suggestion to the fee earners. So fee earners being the paralegals, solicitors, barristers, etc., telling them to just exercise caution when using the AI tools that Halstead & Co. has rolled out. Now, the note has no signature, it has no version number, no review date, and no definition of what exactly is caution. Well, what does caution mean? Exercise caution. It could not be presented to Pemberton Capital as evidence of governance, clearly. It could not answer question 1, and because question 1 cannot be answered, none of the 4 questions that follow it can be answered either. Without a policy, the firm has no governance mandate under which any controls exist. And this is the key gap that we're going to address in this video in module 2, the AI policy document. All right, so without a policy, there is no governance mandate for any of the controls that the subsequent questions ask about. All right. And I've put in here a little bit more detail in terms of the gap itself. So ISO IEC 42001 2023 recognizes 10 control objectives. Okay. Now 8 are technical, and that's register, risk, assessment, life cycle controls, supplier reviews. We're going to address those within these 10 modules. The other 2 are foundational, and that is the AI policy, what we're addressing in this module, and the assessment of roles. Now, until an actual policy document exists, so policy for AI management system exists, none of the other 8 controls have an authorized mandate to operate. And this is why gap 1 is rated as critical, and why it's the first document this program builds. Okay? Doesn't make sense looking at anything else if you haven't got the basic AI policy. All right. So what happens when the policy doesn't actually exist? Okay, so let's look at these four consequences then. Let's look at these four consequences. All right, so revenue at risk. Now, again, Pemberton Capital is Halstead and Co.'s largest client. All right, and the relationship is worth 620,000 per year. The questionnaire explicitly asks whether the firm has a documented IT policy. A no answer is likely to trigger either contract renegotiation or removal from the panel. So Halstead just loses that client that is bringing in 620,000 a year. Okay, so the second consequence is that the CLP PRIA in this case, in this scenario, is totally at risk and is accountable for the SRA Code of Conduct for firms 2019 Rule 8.1. All right, so the third consequence is that you have fee earners acting without any guidance. Now, this could actually cause other problems, which we spoke about in Module 1. Now, Sophie Chen, being the paralegal, in the dispute resolution team, uses ChatGPT 4.0 for legal research. Now, this is without an AI policy. So she has received no formal direction on acceptable use, what she's not allowed to do, and what is the requirements to ensure that whatever output she gets is actually checked and verified before she submits documents to court, for example. All right. Now, in a real case, and again, we went through this on Module 1, we have this court case back in June of last year, where you have, I believe it was page 4, you have, where are we? Here we are, 2 lawyers that use ChatGPT, so a large language model, to identify relevant case law. So they put in a prompt, and the output, they submitted it as verbatim on behalf of their client. Now, unfortunately, what they didn't know, because they didn't check it, because they didn't have any AI policy that guided them in a process of what they was allowed to do, not to do, and the verification steps. What they didn't know is that the AI generated legal analysis that was faulty and contained fictional citations. I believe it was 18 of them. All right. So the AI output was entirely fabricated, falsely attributing nonsensical opinions, to real judges, and embellished with further false citations and docket numbers held by actual cases irrelevant to the matter at hand. Along with it being embarrassing and obviously reputation damage to the law firm and the 2 lawyers, this must be illegal as well. So you're submitting to court false information. So that's how serious it is when you have fee earners acting without any guidance whatsoever. If Sophie Chen, the junior paralegal, does this research using ChatGPT 4.0, and then she just puts all the paperwork together and submits it to court, Halstead and Co. is liable to face serious repercussions in court. And that is, of course, the fourth consequence. So court process exposure. So like I said, if Sophie submits AI-generated research that contains a fabricated citation, exactly what happens is in this court case that I've just mentioned. And I believe the law firm in question, I believe it was, they got fined or something. I believe it was close to 90 million, some ridiculous number like that. So the punishment, the penalty is heavy. And rightfully, you have a client that's paying for your services, your expertise, and instead of using your expertise, you used an AI model and submitted it to court. That's crazy. Now, the firm has no documented policy framework under which the failure was foreseeable, forewarned, or governed. A policy is the firm's first line of defense that it has discharged its supervision obligations. So these are the 4 consequences, and they're quite serious, especially if you're watching this and you're in this field, in this industry, or even a COLP yourself. You would know that, okay, these 4 consequences here: losing a client, the COLP being totally responsible for everything that happens with the compliance of the AI within the firm, you've got the risk of your paralegal team and your disputes team just using AI, generating information that then ends up being submitted to court. That is something to actually worry about. Okay, so let's look at the actual clause and the different bits within this ISO IEC 42001/2023 standard. All right, so clause 5.2 is what we're going to look at first. So what is the obligations for clause 5.2? All right, now we have 10 obligations, and let's break them down. So the different obligations, is shall, should, or may. So let's start with the should. No, actually, let's start from the lowest first. So we're going to start with the may. All right. Now, the AI policy may be integrated with the organization's existing information security policy, provided that the AI specific content is separately identifiable. Useful for firms that want to minimize document overhead, but only when the AI content remains clearly extractable. All right. So you may incorporate the AI policy with your security policy, but there has to be a clear separation with regards to AI specific content and the rest of your security policy, security policy within the firm. Next, we're going to look at what you should do. Now, the AI policy should address the organization's approach to responsible AI use, including ethical principles relevant to the organization's content. A strong policy references the firm's own values, not generic AI principles. Next, the AI policy should define acceptable and prohibited AI use cases in terms the organization staff can apply in practice. Vague language, use AI responsibly or use AI with caution, that fails. Concrete examples would be: do not submit AI generated research to court without verification. And that passed. All right. You've got to be clear within. I say you've got to be clear, but you should be clear with the language used within the AI policy. No vague language. Now we've got 7 you shall requires. The top management shall establish an AI policy. This is the fundamental obligation. Without it, nothing else in clause 5.2 can be met. The AI policy shall be appropriate to the purpose of the organization. So, a law firm's policy must reflect the legal services context, not the obligations of a retailer, a hospital, or a software vendor. So it has to be specific to the business. Now, you could have different AI policies based on the type of business, the type of industries, etc. This module is concentrating on the legal industry, hence why we heavily focus on the SRA standards. Okay? As a law firm, the policy must reflect the legal services and its context. Okay? Next, the AI policy shall include a commitment to satisfy applicable requirements related to AI systems. So for Halstead Cole, this is the SRA Code of Conduct, the UK GDPR, and also the ISO 42001 itself. All named, none is assumed. Next, the AI policy shall include a commitment to continual improvement of the AI management system. This commits the firm to ongoing review, not one-off documents signed and then forgotten amongst the paperwork. Now, the AI policy shall be available as documented information. Documented meaning version control, dated, signed. Not a random email, not a chat message in Slack or Teams, and not a note in someone's head. The AI policy shall be communicated within the organization. So every fee earner, whether that's a paralegal, junior, senior, barrister, every fee earner who uses an AI tool must be able to evidence that the policy has reached them, typically through a training log or some sort of read receipt, etc. But there has to be an actual log that captures some form of receipt or acknowledgement from every fee earner within that law firm that they have gained access to the AI policy and that they have read it as well as understood it. Okay. Then finally, you have the AI policy shall be made available to interested parties as appropriate. So Halstead Co., their largest client, Pemberton Capital, in this scenario is an interested party, hence them sending a 5-question AI governance questionnaire. So they requesting an AI policy. The firm must be able to produce the policy when asked, which if we go back to the beginning of this actual module, Priya wasn't able to answer that question. All she was able to find was a 2-paragraph document that was from the IT director suggesting to the fee earners to have caution when using AI. Okay. All right. So how the SRA's existing rules reach the same answer. So what do I mean by that? Okay. So the SRA has not issued a separate AI policy mandate because it doesn't need to. 3 existing SRA instruments applied together create the same requirement through the code of conduct. The mapping below shows you exactly which rules the AI policy satisfies at the same time. So let's look at this. You've got the SRA and AI guidance. All right, so the SRA's compliance tips for solicitors regarding the use of AI. This was in February 2026. So what does it say? It says the SA has issued formal compliance guidance on AI use. The 3 operative obligations are: solicitors must understand the AI tools they use. Clients must always be told when they are interfacing with AI. Solicitors remain personally responsible for work produced with AI assistance. This guidance was last updated on the 9th of February of this year, 2026, and is the SRA's current position. All right. What else do we have? We have the SRA and competence. So the SRA Code of Conduct for Solicitors 2019. This is Rule 3.2 and Rule 3.3. Now with Rule 3.2, a solicitor must maintain the level of competence and legal knowledge needed to practice efficiently, right? It doesn't mention anything about relying on AI to do any research. The solicitor must maintain their own level of competence and legal knowledge. Yeah, whether that's constantly keeping up to date with regulations and they actually having the knowledge and the research past cases so that they could produce correct citations and things like that. The solicitor must maintain that. AI is not an excuse to drop the ball in those areas. Rule 3.3, a solicitor must supervise their staff and ensure adequate training. The SRA has confirmed that these obligations extend to the AI tools used in practice, which means a solicitor using an LLM for legal research must understand the tool's limitation, including its tendency to produce fake information, false citations. Then we have the SRA and the duties of the COLP. So in this scenario, that would be Priya. So what does it say? The SRA Code of Conduct for Firms 2019, and this is Rule 8.1, Section A. The COLP must take all responsible steps to ensure the firm, its managers, its employees, and interest holders comply with their obligations under the SRA's regulatory arrangements. Now, without a documented AI policy, Priya cannot evidence anything. Okay, the COLP cannot evidence having taken responsible steps to govern AI use. This is the direct line of personal exposure for Priya, like I said. Now, the SRA and their thematic review, which again is this review here that took place in December 2025. Compliance officers, in that review, What did they say? They found that only one C audited could outline all of their responsibilities. The review explicitly flagged that COLPs need to understand obligations arising from technology decisions made by fee earners, not just decisions made by the management. An absent AI policy is today an obvious flag for any future SRA thematic reviews of the COLP's effectiveness. All right. Now, again, this is literally fact, and it's on their website. I believe, where did I got that information from? It was around here. Yes, so we found that a fifth of the compliance officers we spoke to could not explain their record keeping obligations, while only half had read our reporting and notification guidance, and only one individual was able to describe the difference between a notification and a report. So a notification, which means it must be reported to the SRA, and a report, which is circumstances that may have been reported but allows the COLP discretion. Only one out of all that they interviewed was aware that's their responsibility. And that's what this bit here is actually touching upon. All right. So let's look at the 6 sections, mandatory sections rather, of this AI policy. All right. So section 1, commitment to responsible AI use. So this opening section establishes the firm's overall stance. Now what this does, this will satisfy clause 5.2, and its requirements is that the policy includes a commitment to satisfy applicable requirements and include a commitment to continual improvement. So that is going to be section 1. Here's an example that I've put in here. So you'll put in, for example, your firm's name. So in this case, it will be Halstead Cole shall use AI systems in the delivery of legal services only in a manner that is responsible, transparent, and auditable. The firm shall maintain appropriate human oversight of all AI-generated work product used in legal services. The firm is committed to the continual improvement of its AI governance framework and to satisfy all applicable requirements set out in the ISO 42001-2023. Also the SRA Code of Conduct, as well as the UK GDPR. And of course, any other regulatory instrument that applies to the firm's use of AI. So that's an example of the section 1 within an AI policy. I hope you notice that the language is clear. So for example, the use of AI systems in a manner that is responsible, transparent, auditable. Okay. This is not, just using it with caution. This is clear language. All right. So that's section 1. Section 2, acceptable AI use cases. So this section defines in plain language what fee earners may do with the AI tools that gets rolled out. It satisfies clause 5.2 with the should recommendation that the policy defines acceptable use cases in terms of staff can apply in practice. Each use case listed below is conditional on the human oversight requirement, which is in section 4. We'll get to that. All right. But here we've got the permitted use cases. So legal research assistant, where every output is independently verified by a qualified solicitor before reliance. Okay. So this independent verification will spot any false or fake made up citations. Then we've got document drafting assistant, where all AI generated content is reviewed and edited by the responsible fee earner, right? So their output that they get, they're going to review the whole document that they've got AI to help them draft, and they're going to make the corrections and sign it off before it gets submitted or put together towards a case. Next, we've got the document summarization for internal review purposes only, not for client delivery without rewrite. All right. So the client never gets AI generated information. The information they get is always been edited, updated, changed, amended by a responsible qualified solicitor. All right. So summarizing documentation is only for internal review purposes. Next, we have administrative tasks, including billing, narrative drafting, scheduling, and internal correspondence. This will be more in line with certain elements of Copilot being incorporated in Microsoft, as well as the Leap AI, which is a specific AI billing, I believe it's a billing tool for the legal industry. All right, so administrative tasks. And then finally, you've got client communication drafting. So this is where outputs are reviewed by the responsible fee earner before sending, and the AI disclosure statement is referenced where relevant. So any information that the client gets is always going to be put together by a human. And if there is any elements of that message or communication that is generated by AI and unchanged, that there is going to be a AI disclosure statement to make the client aware that that particular information has been created by AI. All right. Now, the list must be adapted to reflect the actual tools Halstead & Co. uses. A firm using only Microsoft Copilot will have a narrower list than a firm deploying bespoke API-connected LLMs. So that's section 2. Section 3 of the AI policy is prohibited AI uses. So, equally important as defining what is permitted is defining what is forbidden. So this section satisfies clause 5.2, which is the expectation that the policy addresses limitations clearly and operationally. All right, so prohibited uses include submitting AI-generated legal research to court, tribunals, or regulatory bodies without independent verification by a qualified solicitor. Doing so can end up with this right here. Using AI to conduct client due diligence, you have the AML risk assessment, and what that is the anti-money laundering risk assessment, or the compliance activities as a substitute for qualified human assessment. So that is prohibited. What also is prohibited is uploading client documents or client personal data to any AI system not listed in the firm's AI system register and approved under the firm's data governance controls. So when you have ChatGPT, and with that interface, you have the ability to attach documents for ChatGPT to read, scan, summarize for you. That is prohibited. Now, what also is prohibited is providing autonomous legal advice to clients via AI system without qualified solicitor review or sign off. Finally, you have using personal and consumer grade AI accounts. For example, free tiers of ChatGPT, or in some cases where you have fee earners using their own account, pro account, to work on matters relating to their work. That is prohibited. Those fee earners should be using the firm's approved enterprise tools and accounts only. All right, so these prohibitations are not suggestions. A breach of this section is a breach of the firm's policy and is reportable to the COLP under the firm's incident procedure. So this is the prohibited AI use cases in section 3. Now we're going to look at the human oversight, which is section 4. Now this is a non-negotiable requirement. So human oversight is the single most important operational safeguard. This section translates the policy principle into a binding operational requirement, satisfying ISO 42001 clause 9.1, which is monitoring and measurement, as well as the SRA rule 3.3, which is supervision. All right, so I've provided some draft text here of what the language would be. So human oversight of AI outputs is a non-negotiable requirement of this policy. No AI generated output shall be submitted to a client, filed with a court or tribunal, or used as the sole basis for a legal decision without review and sign off by the responsible qualified solicitor. The sign off shall be documented in the firm's matter management system. Now, when it comes to the client matter management system, I've actually built a mini solution for the legal industry with regards to that system, which is fully compliant to the SRA Rule 3.3. That will be a later video after we've actually completed this module, so look out for that. But anyway, let's continue. Now, the detailed procedural requirements: minimum review by output type, sampling cadence, sign-off record format are defined in the procedural AI management system human in the loop. The human in the loop oversight procedure covered in module 5. So we've got a few modules to go through before we get there. But the human in the loop oversight procedure covered in module 5. The policy AI management system establishes the principle. The procedure defines the mechanism. All right. So policy established the principle, while the procedure defines the mechanism. Next, we have section 5. So this is the AI disclosure to clients. Okay, so transparency in the firm's most visible AI obligation under SRA's February 2026 guidance. This section commits the firm to a defined disclosure practice, satisfying both the SRA's make clear to client requirements and Annex 2, which is transparency. So again, I've provided some draft text here. So the firm, in this case of the scenario, Halstead Co. Halstead Co. shall make clear to clients where AI systems are involved in the delivery of legal services, in accordance with the SRA's AI guidance from February 2026 and the firm's AI transparency disclosure statement. The disclosure shall be provided at matter opening and whenever a materially new AI system is introduced to the delivery of the client's work. All right, so that's some just drafted text there. Again, take note of the clear language used. There's nothing vague about how Halstead Co. is going to communicate their use of AI to clients. It's very clear. Now, the full disclosure wording and the trigger criteria for the redisclosure is covered in Gap 7. So we'll get there. And what that does is it addressed in module 4, as well as the policy AI management system acknowledges the obligation as well. The disclosure document operationalizes this. Okay, I hope that makes sense. Finally, we have section 6. Now, section 6 is the review cycle and ownership. Now, the clause 5.2 requires a commitment to continual improvement of the AI management system. This section defines what continual improvement looks like operationally, an annual review, and 3 defined review triggers, as well as the named owner. All right, so let's look at the drafted text I've got here. This policy shall be reviewed annually as a minimum by the COLP, with the outcome of the review presented to senior leadership for approval. An immediate review shall be triggered by a material change to applicable regulatory requirements, the deployment of a significant new AI system, or any AI-related incident classified as high or critical. The COLP shall maintain the policy as a controlled document in the firm's document management system. Now, without a defined review cycle, a policy becomes a historic artifact. Okay, so once it's written, it's filed away, it's forgotten. The addition of the annual minimum with immediate trigger within the text of the policy, the formulation is the working standard expected by ISO 42000 auditors. Now, I've got a template here, which you could download. This in the link in the description, and you could also get it from the Governance Academy. A simple Word document, and I have just outlined what the actual policy document would look like in terms of the different sections and the drafted text. Feel free to download this and update it, amend it according to your actual law firm. I just wanted to provide you with some extra value so that you could see an actual document, or you have a base template to work with when creating your first AI policy. All right, so let's continue. How does the policy AI management system signed, version controlled, and filed? Okay, a policy without document control is not a controlled document. It's a memo, it's a email, it's a Slack message. Now, ISO 42001 clause 7.5 requires that all AI management system documentation carry a defined set of metadata, that is ID, version, owner, classification, issue date, review cycle, retention, and related documents. The block below shows what Halstead & Co.'s control block looks like when they have an AI policy ready to sign. So let's take a look. So you've got the access control here, and we could actually use the template. So on the template, there we go. This section here is the section that we're talking about right now, control document. So you've got a document ID, you've got the title of the document. So AI policy, AI management system policy. You've got the standards that it's referring to. So you've got the ISO IEC 42001 2023 with its different clauses and annexes, as well as the SRA Code of Conduct for Firms 2019 and the rule that it's associated with. And it also includes the ISO 2015 edition and its clause, which is clause 5.2. So part of this section also tells you what standards that it's referring to. It's got the classifications. So this document is internal, it's controlled, and it's available to interested parties upon request. It's got a section where when is the document going to be reviewed again? So it has an annual review as a minimum, and also there's an immediate trigger if there is something changed with regulations, or there's a significant new change, i.e. a new model, or if there's been an incident that is high or critical. So every time one of these happens, this whole document gets reviewed. All right. You've got the version control and you've got the current status. So in this case, it's ready to be signed and awaiting signature. Now, the owner of this document, of course, is going to be the managing partner, senior leadership. The COLP is going to be maintaining and reviewing the document. The managing partner and leadership is going to sign off this AI policy document. Then you've got a date of issue and a retention time in terms of how long the retention of this document is, and it's in line with the UK Companies Act 2006 for 7 years. All right. So that is what the control block actually looks like, and here's the example of it here on the downloadable template I have for you. So you got the refs, you got the owner, classifications, date issued, all that information there that we just went through. Okay, cool. Now, what happens after this AI policy is signed? Okay, so the senior partner signs the document. So this status changes from draft to active. The date of the issue is recorded. The 7-year retention clock starts. Every other AI management system document now has an authorized policy framework under which to exist. In module 3, right through to module 10, we're going to go through all the actual documents that now satisfies this AI policy. Okay, so continuing on throughout all these modules, we're going to go through all the different documents that closes the gap that you're meant to have before you incorporate AI within your business and roll it out throughout your company. Okay, now, so that's literally day 0, the moment the document is signed. Now, within 14 days, firm-wide communication. So every fee earner receives and acknowledges the policy. Now, according to clause 5.2, what it requires is that the policy to be communicated within the organization. Now, the best practice is 30 minutes briefing session per practice area, followed by an acknowledgement log. So everybody acknowledges, all fee earners acknowledges and understands this policy. Each fee earner signs to confirm that they have read section 2, 3, and 4, the operational relevant sections. The COLP retains this log. All right, now day 30, this is the deadline for which Pemberton's questionnaire needs to be answered. Question 1 can now be yes, with confidence. Halstead & Co. now can respond to Pemberton's capital questionnaire with a copy of their AI policy attached, the £620,000 revenue client. The relationship is protected. The first 5 questions is answered, and the firm's broader AI management system work has a defensible foundation in place. Now, when it comes to days 30 to 90, those days are going to be used to close the remaining gaps. And those remaining gaps are the gaps that we're going to cover from module 3 to 10. All right, so gap 1 is closed. Gap 2 through to 9 is remain. That is roles, AI system register, the risk assessment, the life cycle controls, the data governance, the transparency, the human oversight, and the supply chain. Each is the focus of one subsequent module, and all of them refer back to this AI policy as their policy of authority. Now again, what we've just gone through is available. Just click on the link below. It will just take you to this URL, and you could go through this document again, rewatch this video as well. And I've put in there some test questions to test yourself if you've understood what we've gone through in this module. I'm not going to do it here because it will expose the answers. Feel free to click on the link below in the description and also download the template and make use of that. And if you have any questions, reach out to me in the comment section and we could take it from there. As an added bonus, I've also added in a kind of completion checklist. So as you're working through your AI policy, there's a few things here that you could go and just track your actual progress. So understand the scenario. And the key thing here with the scenario is put yourself in Halstead Cole's shoes. Are you using ChatGPT or any other AI, like Google Gemini, for example, within the business? Are you using Copilot if you're on Microsoft? Cool. That's great. That's fantastic. Do you have an AI policy in place? Does your staff who are using these AI tools knows what the company rules are, what they should and shouldn't be doing? Simple questions to ask yourself internally. Okay. If you are a COLP for your firm, this should be hugely concerning to you. If you know that there is AI use in the organization and there isn't a policy in place with the relevant structures that goes with that policy to make sure that you're compliant with regards to the ISO IEC 42001 2023, as well as the relevant clauses within the SRA. Okay, so that's the end of module 2. In module 3, we're going to move from the policy to people. So Halstead & Co. will produce its governance structure. That is the RACI matrix. And what the RACI stands for is responsible, accountable, consulted, informed matrix. All right. Which is going to be its own document, assigning the AI risk owner, the AI system owners, the AI management system program lead, as well as the human in the loop reviewers. Once these roles exist with named individuals, the firm will be able to answer question 3 and 4 of the Pemberton Capital's questionnaire and complete the operational half of the AI Management System Foundation. Okay, so thanks for watching. Make sure you make use of the template, and again, click on the link to get access to this module 2, where you could work for it yourself, answer those quick quiz questions that I've got here. That will just help you test you to see that you've understood the actual module itself. And also I've provided a checklist while you're working through understanding the module, as well as working through creating your own AI policy for your organization. You could use this checklist to follow along and make sure you've covered all the relevant steps. For now, this is the end of module 2, and I'll catch you over in module 3.